wonderful to see everyone here, and looking forward to this evening. I want to welcome you to our fifth Shabonglos Water Lecture. This is a lecture series that's funded by an endowment from George and Rosemary Shabonglos. They're both alumni from the University of the Pacific. Following their graduation some years ago, George became Dr. Shabonglos and embarked on a successful career as a professor of civil engineering at UC Davis. As a result of his work in environmental engineering, we have more resilient and effective water systems today. His work has had a global impact, and his engineering design guidance is followed throughout the world. This lecture series was created to facilitate cross-campus interdisciplinary discussions regarding water. Specifically, Pacific's McGeorge School of Law and the School of Engineering and Computer Science have partnered together to host this lecture series highlighting the intersections of law, engineering, science, policy, and other disciplines. George and Rosemary Shabonglos hosted this lecture series inspires students to engage in the work of protecting water resources for future generations. This lecture was organized, or all these lectures are organized by myself, Mary Kay Camarillo, Associate Professor of Civil Engineering, and also by Jennifer Harder, Professor of Water, Environmental, and Public Agency Law at McGeorge School of Law, and also the Principal Faculty Member in McGeorge's Water and Environmental Law Program. Here's Jennifer. Also, I'd like to thank all of the staff and faculty for making this possible, and of course, George and Rosemary Shabonglos. So we're here tonight to discuss international water law. This is a topic of interest because of the importance of ensuring safe, accessible water worldwide, but also important because of the interconnectivity of water, air, and climate. In an age of dramatic human impact on the planet, which is the Anthropocene, if you weren't sure about that, a global view of water is becoming more and more essential to us. Our distinguished speaker, Professor Stephen McCaffrey, will develop a presentation on the development of international water law and its current state in the Anthropocene. Dr. McCaffrey is a professor in the McGeorge School of Law and a globally recognized authority on international water law. As a result of his innovation and progressive work, he was awarded the prestigious Stockholm Water Prize in 2017. There's a YouTube video. It's really fun. I highly recommend
Oh, no.
it. If you're in my class, you've already seen it. So Professor McCaffrey provides legal counsel on transboundary water issues in Africa, Asia, South and Central America, and his work results in conflict resolution, environmental protection, and equitable sharing of water. And so with that, I welcome Professor Stephen McCaffrey.
Can I get some water?
Oh, yeah.
Thanks so much for that very kind, generous, mostly true introduction. It's really a great pleasure and honor to have been invited to give this year's Shabonglos Water Lecture. I'm also honored to, join the list of those who have given this lecture, including one of its founders, before me. So I've got a tall order to fill to measure up to these folks. It may take me a few tries to get things to work here. We'll see. Yeah. Oh, there we go. Precisely what I wanted, even. Yes, you recognize this planet. We live on a blue planet. This iconic image taken by the Hubble Space Telescope shows our beautiful planet, Earth, in all its glory, with water apparently everywhere. Life would be impossible without it. Scientists search for signs of water as indications of life on other planets, as we all know. The U.S. National Aeronautics and Space Administration, NASA, puts it this way in speaking of efforts to find life on Mars, because almost everywhere we find water on Earth, we find life. This is true of both salt water in Earth's oceans and fresh water. But in terms of quantity, the former dwarfs the latter. This is from a very interesting and useful publication called Vital Water Graphics, prepared by United Nations Environment Program. If you, now I'm not sure how this is going to work, but we'll see. It's not live. I'm not sure how to get it to come on. Well, anyway. You can see that salt water constitutes most of the water on Earth. And I don't think that's a surprise. The surprise comes later. Fresh water is only 2.5% of all the water on Earth. And how it breaks down is of particular interest, because when we think fresh water, when most people, anyway, think about it, they think about lakes and rivers and that kind of thing, right? Well, this is how fresh water breaks down. Most of it is basically locked in polar ice caps and glaciers. We used to say locked in this era of climate change. I'm not sure you can say that anymore. But that's where most of the water is. It's in Greenland, it's in Antarctica, less so in the North Pole. Santa Claus, I don't know where he's going to live anymore. Anyway, that's about 70% of Earth's water, fresh water. The next biggest portion is in the ground. So just over 30%. And look at this, 0.3% of our fresh water is in lakes and rivers. That's all, 0.3%. And that's 0.3% of this 2.5%. So you can see how precious our freshwater resources really are, right? We perhaps take them too much for granted, and I love this graphic because it makes so plain how limited our freshwater supply is. We know that the quantity of water on Earth has been pretty much the same for around 3 billion years. It's been observed, and maybe you've all had a bite to eat tonight already, that last night's potatoes may have been boiled in Archimedes' bathwater. I hope not. We also know that most of the water on Earth is in constant motion through the hydrologic cycle. And we're all aware of this. You've probably seen a graphic like this in grammar school. But you can easily see how this works. Water evaporates from the ocean or really any wet surface. It evaporates from leafy plants through evapotranspiration. It goes up into the atmosphere, condenses, falls down in the form of some kind of precipitation, rain or snow, and then goes through the ground or on the surface back to the ocean, or to perhaps it just evaporates from wherever it fell, so back into the sky, and you have the cycle repeated endlessly. The hydrologic cycle. This fact of constant motion of water through the hydrologic cycle makes water, together with air, the quintessential shared natural resource. We all share it, right? But while humans haven't yet figured out how to confine air to keep it away from other societies, fortunately, probably only a matter of time. We have come up with mind-blowing engineering works that can move enormous quantities of water from one place to another, not to mention dams and the reservoirs they form. And this, I don't know if you can guess what this is, but this is the great man-made river whose brainchild it was of Colonel Muammar Gaddafi, the late Colonel Gaddafi. And the scale's a little bit off here, but one of these trucks could probably drive through that pipe. It's an enormous pipe, and it takes water from aquifers in southern Libya. In fact, aquifers that are shared with 2 or 3 other countries. It pumps it from great depth up into this pipe and takes it to the coast, where it's used for agriculture, municipal and domestic purposes. So that's a pretty impressive feat right there, I'd say. As far as dams are concerned, this is another iconic image, Hoover Dam. You can't really talk about dams without seeing a picture of Hoover Dam. What you're seeing increasingly, and have been for the last 10 or 15 years, is this bathtub ring around Lake Mead, which is impounded by Hoover Dam, and which has resulted from the drought in the Southwest, for which we probably should find another name, because drought connotes unusually low rates of precipitation. But now it's always low, it seems. And so this bathtub ring has been there now for some time. Our own state of California, of course, provides plenty of additional examples of these kinds of grandiose engineering works. This is the Central Valley Project, the federal project, taking water some 400 miles from the northern part of the state, our part of the state, down to Southern California, our water. No, we can't say that, because it's a shared natural resource, right? But anyway, we have these projects. They do take water for great distances from where the water is to where people want to live. And sometimes I can't fathom why they'd want to live in these places, but that's another story. Returning to an earlier point, the quantity of water on Earth is both finite and static. The human population, on the other hand, continues to grow. This graph shows that while it took all of human history to reach this point, 2.5 billion people in 1950, it took less than 40 years to double that. So you come up to 5 billion and you're in the 80s, 86, 87, somewhere in there. I mean, that boggles my mind. All of human history to reach 2.5 billion and then 40 years to double that. And everyone is relying on the same amount of water, right? The UN Population Division projects, and it's a medium-term projection, that by 2050, our population will be 9.5, 9.8 billion. And then it will level off and gradually go down, decline, and how far and whether it'll go back up again, we don't know. So we have this remorseless calculus, constant amount of water, more and more people who rely on it. And this sets up, obviously, a scenario in which conflict over water seems almost inevitable. Zoom out a bit and consider how much of Earth's fresh water is shared not by Northern and Southern California, but by different countries. The answer, in short, is a lot of it. This is a map of the world's international or transboundary drainage basins. You can see they cover quite a bit of the surface of the Earth, including some pretty important places like North America, much of South America, practically all of Western Europe, much of Africa, Asia, Central Asia, South Asia. I don't know why Australia, well, we're looking at transboundary basins, right? There's the Murray-Darling Basin in Australia, of course, that goes between different political units there in that country. There are some 310 now transboundary river basins in the world. Those numbers seems to be ever increasing as science and technology helps us to trace freshwater systems more accurately. The basins cover some 47% of the globe's land surface, so nearly half of it. And it's a very important half, as I just mentioned. Some 45% of the global population lives in these transboundary basins. So you can see that when you have the pressures and stresses I mentioned earlier associated with fresh water, and where much of this fresh water is shared by a growing population, it doesn't take much imagination to think what some of the consequences of that might be. All right, so we're talking here about surface water and basins, really, which includes both surface and groundwater. But we saw in the earlier slide that most of Earth's fresh water is actually underground. And so this map shows groundwater basins and aquifers. It really, as you can see from the table here, the caption, what they're trying to give you a feeling for is how much is underground. And the darker the color blue, the more water is there underground. We have some white spaces where research hasn't been done, apparently, but you can see that there is a lot of groundwater. It's all over the place, and in some instances you have especially heavy concentrations of it. So that's something to keep in mind for the future, especially in places where groundwater hasn't been tapped to a very great extent. There are something like 592 transboundary aquifers that have been identified, but this number as well is likely to increase as our technology for identifying aquifers improves, in particular through further mapping by NASA's Revolutionary GRACE project, which has really identified a lot of aquifers, including transboundary ones. Most of these aquifers are recharging. That is, they are replenished by infiltration of surface water or precipitation. Some don't receive significant recharge and are very deep, containing what is aptly termed fossil water because of the age of that water. And there's actually a lot of it in places such as North Africa. But it's accessible only by drilling very deep wells, whose operation takes a lot of energy. So as a practical matter, fossil water in significant quantity is available for the most part only to countries that are rich, have readily accessible sources of energy, such as fossil fuels, no pun, or that receive massive development assistance from the international community. And there are cases in which that's true as well. Okay, to summarize what we've reviewed up to this point then. Water is necessary to life. The quantity of water on Earth is finite, but the human population is growing. and much of Earth's fresh water is shared by 2 or more countries. The next question is whether there is any regulatory or governance structure that applies to the sharing of freshwater resources. So next I'd like to turn to the development and importance of international water law. Let's see here. Okay, you all recognize the United Nations headquarters in New York, undoubtedly. As early as 1970, it doesn't seem so long ago to me, but it is actually, the United Nations General Assembly, if you've never been there, you should go there. It's a very impressive hall, recognized the phenomena I've been talking about, and many of which I think most of you knew about before even coming into this room, and did so in a resolution in which the General Assembly asked one of its subsidiary bodies, the International Law Commission, to study the law of international watercourses. Among the desiderata, or considerations mentioned in the resolution's preamble, are the following. Ha ha ha. I bet you thought I wouldn't have any words up there in the slides, didn't you? Now, I just wanted to show you what the official record of these resolutions looks like. I don't expect you to be able to read any of that. But the relevant resolution starts here and goes down to there. And I will read one thing from it because I don't have it on a slide. This is the title, Progressive Development and, I can't read the next, Codification of the Rules of International Law Relating to International Watercourses. That's the topic of the resolution. And here are several of the introductory preambular paragraphs, and the first principal paragraph, operative paragraph of the resolution. And I hope you can see these. I'm just going to read through them quickly to give you an idea of what was in the mind of the General Assembly. And the General Assembly isn't some throbbing thing that has its own mind. We're talking about all of the members of the United Nations, which includes substantially all the members of the international community. So it says, the General Assembly, considering that water, owing to the growth of population, we just talked about that, and the increasing and multiplying needs and demands of mankind, today we'd say humankind, is of growing concern to humanity, that the available fresh water resources of the world are limited, and that the preservation and protection of those resources are of great importance to all nations. Great. Conscious of the importance of legal problems relating to the use of international watercourses, inter alia with regard to international water resources development, read dams and such things on international watercourses that are shared by 2 or more states. Recalling that despite the great number of bilateral treaties and other regional regulations, so there are hundreds of bilateral treaties between 2 countries, right, concerning fresh water they share, as well as, and then they name 2 League of Nations era multilateral treaties. The use of international rivers and lakes is still based in part on general principles of customary law. Strange sounding thing. And then the final one that I quote here, convinced of the necessity to promote the work on the progressive development and codification of the law of international watercourses, and to concentrate this work within the framework of the United Nations. 1, recommends that the international, as a first step, take up the study of the law of the non-navigational uses of international watercourses. That's a mouthful, but get used to it. To its progressive development and codification. Okay. That's all a bit of a mouthful, but it shows that the Assembly, representing the international community, drew a connection between humanity's increasing reliance on fresh water and the need for authoritative confirmation of the rules of international law governing its sharing by states. 2 points in this resolution require clarification. First, what is customary law? And second, what is the International Law Commission? And I'll just have to be brutally brief, at least for you. The whole thing is probably brutal, but but brutally brief in the sense that I'm not doing justice to these, but I'll take a stab at a quick explanation. First, customary international law. This occupied most of the field of international law until after the Second World War, when countries acting largely through the United Nations began concluding multilateral treaties, most of which were open to accession by all countries in the world. Up until this point, most of the multilateral treaties were peace treaties, so there weren't that many of them really, but treaties ending great wars, Peace of Versailles, for example. But the international community wasn't organized. Even in the League of Nations, it wasn't as organized as it was in the United Nations, as it is in the United Nations. So more and more multilateral treaties, because of the number of countries that subscribed to these agreements, they were often called law-making treaties, because they were the closest thing the international legal order had to legislation. They bound most of the international community, as many states as became parties. But even this framework agreement does not and cannot cover everything. So enter here customary international law. It didn't ever get thrown out. It didn't even get squeezed out by these multilateral agreements. It was always in the background. And I can tell you, I've had the privilege of being involved in a number of cases before the International Court. Every one of them involved a treaty, but most of the argument was about customary international law. Why? Because treaties can't cover everything. It's like a statute. You can have a civil code, right? And you can have a criminal code, whatever. Next thing you know, the week after it's promulgated, up comes a case that's not covered, right? So how do you deal with that? Well, in the common law system, we deal with it by judge-made, court-made law. In the civil law system, normally they deal with it by interpreting the text of the statute. In the international law field, we basically fall back on custom, but we also use custom, which is shorthand for customary international law, to interpret the terms of treaties. Customary international law is a body of law formed by state practice, generally over a period of time. The practice has to be followed to give it legal effect, has to be followed out of a sense of legal obligation by the states participating in it. So customary international law, or simply custom, is a general practice followed by countries out of a sense of legal obligation to do so. It's every bit as binding as treaty law. People tend to think, well, you have a treaty, that's binding, it's like a contract. And you have custom, it's not so binding. That's not true. Custom is law, as long as it qualifies as customary international law. Its chief weakness is that until it's authoritatively written down, there's always room for argument about what it is and what its contours are, right? Because it is formed of state practice. And there are these people who sit in their offices and spend hours researching things and trying to write down rules of customary international law. They're sometimes called professors. I don't know. And so that is one means of getting evidence of customary international law. Another means is decisions by courts that say, we find that this is now a norm of customary international law. It's crystallized. That term is actually used. Isn't that beautiful? it's crystallized as a norm of customary international law because there's been sufficient state practice out of a sense of legal obligation. So this is one of the things that this International Law Commission, or ILC, tries to do. And the ILC is the second point I should clarify. It's an expert body established by the General Assembly in 1947 to carry out the mandate of the Charter, the UN Charter, that the General Assembly engage in studies and make recommendations for the purpose of encouraging the progressive development of international law and its codification. And of course, what was in the minds of the drafters of the Charter was, when they said international law, progressive development of international law and its codification, was customary international law, because that was the main reservoir of international law at the time. Members of the ILC, they are elected by the General Assembly and serve in their personal capacities as experts. So it's a scary thought, but like getting a bunch of professors together. Scary thought to those of you who are students anyway. They're not beholden to anyone, in theory, right? I was privileged to serve 2 terms myself on the International Law Commission from 1982 to 1991, which, as you can tell, most of it was during the Cold War, so that was quite interesting. Professor Nikolai Ushakov was a force to be reckoned with on the International Law Commission. Of course, he would say that he served in his individual capacity as an expert. On the other hand, there were interpreters up in the Russian booth who kept a close eye on him, so I'm not sure. In any event, the Commission has done this kind of thing, has studied carefully, written down rules of customary international law, and made recommendations for the progressive development of the law where that's needed. It's done this, for example, for the law of the sea and the law of treaties, and a number of other subjects. Okay, now back to the resolution, which referred the international watercourses topic to the International Law Commission. This was in 1970, remember. The Commission didn't take it up until '74 because it was too busy with other things. In 1994, 20 years later, the Commission sent a complete set of draft articles, which looks like a draft treaty, to the General Assembly on this subject of international watercourses. And that a treaty should be negotiated on the basis of the draft prepared by the International Law Commission. This ultimately resulted in the adoption by the General Assembly of the 1997 United Nations Convention on the Law, don't go to sleep while I say this, of the non-navigational uses of international watercourses, 1997. And this is just the heading of the resolution to which the convention's another word for treaty in international law, was annexed. The Watercourses Convention entered into force in 2014. It has 36 parties at present, but in view of its provenance, where it came from, how it was developed, as the outcome of an exercise of codification and progressive development, it's more significant really as a codification of the fundamental rules of international law than it is as a treaty. So the customary rules embodied in the convention, reflected in it, are binding on all states, regardless of whether or not they're parties to the treaty. Of course, some states don't have any international watercourses. I suppose you could argue that even Australia participates in the hydrologic cycle. No, I won't go there yet, anyway. So let me just say a very few words about the main customary rules that are reflected in the 1997 convention. And parenthetically, again, I say reflected because these are rules of customary international law that are replicated in the convention on the basis of the International Law Commission's work. The core principle of international water law, in my view, and I think this is reflected in the convention, is contained in Article 5 of the convention. And it is that the waters of an international watercourse must be used by the countries sharing them in a manner that is equitable and reasonable vis-a-vis one another. I don't want to spend time reading through this, but I've tried to put in bold the main point of each of the paragraphs. Watercourse states shall in their watercourse states is a defined term meaning a state sharing an international watercourse. Shall in their respective territories utilize an international watercourse in an equitable and reasonable manner, and this goes into more detail on what that consists of. Paragraph 2 is very interesting, and it's really an innovation. Equitable participation, equitable and reasonable participation. Watercourse states shall participate in the use, development, and protection of an international watercourse in an equitable and reasonable manner. Because generally speaking, if you share freshwater resources, work has to be done to protect the ecosystems, to protect the banks from eroding too much, all kinds of things, dredging it maybe, to provide for navigation and other uses. So equitable participation kind of embraces all of those tasks that are often necessary so that you can derive optimal uses from the watercourse. This is a case whose name is difficult to pronounce, but I make my students do it, and I put a little microphone in their final and make them say it into the, you know, no, I don't really, but that this basic principle of equitable and reasonable utilization is a cornerstone principle, was underscored 4 months after the UN Watercourses Convention was adopted. In this case, this Gabčíkovo-Nagymaros case. And in that case, the court said something that you can't read probably either, but it referred to a country's, Hungary's in this case, basic right to an equitable and reasonable sharing of the resources of an international watercourse. I'm not sure, I mean, I'm an international lawyer. I'm not sure what that means. We talk about basic human rights, but a basic right to an equitable and reasonable sharing of the resources of an international watercourse, that's kind of mind-boggling. So if that is a basic right of a state sharing an international watercourse, it's a pretty powerful kind of right, and the correlative obligation on the part of the other state is also quite impressive, right? So that, again, I just cite as evidence that equitable and reasonable utilization is probably the cornerstone principle in the field. Another basic principle is the obligation to prevent the causing of significant harm to other countries. And again, I've given you Article 7 here, 2 paragraphs. This article was the most controversial, believe it or not, of the entire convention during the negotiations. And the reason, the basic reason for that was that it wasn't clear what the relationship between no harm and equitable utilization was. And I'll give you an example. On the Nile, Ethiopia is an upstream state, and out of Ethiopia come 3 rivers that contribute about 85% of the water reaching Egypt to the Nile. And one of the rivers, the Blue Nile, alone contributes 60 to 65%. But Ethiopia really hadn't significantly developed those water resources. Why? Because it rains up there on the Ethiopian plateau. They can have rain-fed agriculture. They don't need irrigation. Egypt downstream, on the other hand, gets hardly any precipitation. I've only been there 3 or 4 times. Twice when I was there, it rained. I mean, they should invite me back, right? But very little rain. They rely almost entirely on the Nile. Now, increasingly, that we know more about groundwater resources, there's this Nubian sandstone aquifer, which holds a lot of water and is shared by a number of countries in northern Africa. But the point is that Egypt always felt that it had a priority of right because its use only went back 2 or 3 millennia of the waters of the Nile, right? And so it said, look, Ethiopia, you can't touch that water because we've been using it forever as a practical matter. And if you use it, that's going to cause us significant harm. Ethiopia, on the other hand, relied on the equitable utilization principle and said, it's not fair, it's not equitable for you to tell us we can't touch that water. Now that we have the resources, hydropower dams, at least, which aren't going to hurt you, by the way, because all the water eventually is going to go through them, we should be allowed to do so. And Egypt said, no, no, no. Well, that impasse was solved recently by Ethiopia's construction of the modestly named Grand Ethiopian Renaissance Dam, just upstream, 20 kilometers, I guess, upstream from the border with Sudan. And this is still in process, the reaction of Egypt to this dam and so forth and so on. But that, in any event, is the tension between these two principles. I believe that the two are compatible. That is a practical matter, and this has happened time and again in disputes between U.S. states over shared water resources. When one state gets hurt, injured because of water use in another state, it will cry foul. It will say, I've been injured, come on, stop it, or give me some kind of redress. The other state will respond as it will. But the ultimate solution has to be an equitable and reasonable one. It doesn't mean, well, we'll see in a minute, but it doesn't mean that you can just say, sorry, I deem my use to be equitable. It means that the two states have to deal with this in a reasonable way. Okay. So these and other principles, and I've only given you 2, but I think the most important ones, were developed for a significant period of time and under a climate regime that was quite different from what climate change is already bringing us today. So the question I'd like to address is whether the principles of traditional international water law still make sense in the present era of climate change. And of course, I can't give this adequate treatment either, but I'll just maybe raise a couple of possible points here. We are actually living in what some scientists are describing as a new geological age, the Anthropocene. This epoch, which would supersede the Holocene, which I was taught about in school, and which otherwise would still exist and perhaps still does exist technically, is characterized, the Anthropocene epoch is characterized by the influence humans have had on the planet and its systems. This name and the new age was first proposed by an atmospheric chemist, a Nobel laureate, Paul Crutzen, and a biologist, Eugene Sturmer, in a paper published in 2000, the year 2000. They use the term Anthropocene to refer to the fact that we're now living in the age of humans, that humans are the dominant influence on Earth's climate and therefore our global environment. But whether or not we're living in a new geologic age, signs that the climate is changing and that those changes are having significant impacts are all around us. And I don't need to tell this audience that, I don't think. Of course, here in California, the horribly destructive Camp Fire, as well as the Carr and Mendocino complex fires, were fueled by unusually dry conditions, plenty of dry brush and grass, and high winds, and perhaps a public utility that didn't keep its lines repaired, but that's not the object of my remarks, so I'll leave it there. These blazes and others in Southern California have focused our attention on how climate change creates the conditions for such cataclysmic events. Perhaps surprisingly, perhaps unsurprisingly, I should say, climate change has also had significant impacts on fresh water. In fact, it is said to have already sped up the hydrologic cycle. We know that California's largest reservoir, the Sierra snowpack, is smaller and is melting faster due to the influence of climate change. What used to fall as snow is now falling as rain in many places, and what does fall as snow melts faster than it used to. And on the screen is the cover of the last part of the last report prepared by the Intergovernmental Panel on Climate Change, AR5, Assessment Report 5. So for me, the best and most useful source of information on climate change is the IPCC, the Intergovernmental Panel on Climate Change, and its reports. It was established in 1988 by two United Nations organizations, the World Meteorological Organization, the WMO, and the United Nations Environment Program, which today I think they call UN Environment, but we've always known it as UNEP. The IPCC produces reports that support the 1992 Framework Convention on Climate Change. It's actually the United Nations Framework Convention on Climate Change, so the abbreviation is UNFCCC. Say that 5 times fast. This is the main global treaty on the subject of climate change. It has lots of parties. I'll get to that in a minute. The treaty, this is the treaty under whose umbrella the famous, now famous, Paris Climate Accord was adopted. Many will no doubt recall that the 2007 Nobel Peace Prize was shared by the IPCC and who else? A person. A presidential candidate. Al Gore! That's right. Give that person a prize of some kind. So in October of last year, the IPCC released a special report on the effects of global warming of 1.5 degrees Celsius above pre-industrial levels. Humans have already caused global warming of around 1 degree Celsius above pre-industrial levels. There are 196 states that are parties to the 1992 Framework Convention on Climate Change, the UNFCCC. This is pretty impressive when you realize that there are only 193 members of the United Nations. So there are 3 more states, and I don't know where they found these 3 more states, but anyway, 196 parties to this global treaty on climate change. These parties had been assuming that the red line, the temperature rise that all countries should do their utmost to avoid, was an increase in the global mean surface temperature of 2 degrees Celsius. The assumption was that the impacts of an increase of less than 2 degrees would be manageable. Not necessarily so. I think there's a song about that. It ain't necessarily so, said the IPCC in its special report. A rise of 1.5 degrees will already bring serious disruptions and other consequences. And IPCC scientists reported high confidence that global warming is likely to reach 1.5 degrees Celsius between 2030 and 2052 if it continues to increase at the current rate. And all signs are that it is. In fact, the rate itself seems to be increasing. I believe the math is that even if all the countries that were parties to the Paris Accord complied with their individual commitments, the global temperature rise would be 3 degrees, 3-point-something degrees. So that agreement is a good start, but it certainly isn't sufficient. So in its fifth assessment report, I'm leaving you before I'm ready. The most recent full report it's prepared, the IPCC found that, quote, climate change can alter the availability of water and therefore threaten water security as defined by UNESCO, the United Nations Economic, Social, and Cultural Organization. It also reported that, quote, about 80% of the world's population, 80% of the world's population, already suffers serious threats to its water security as measured by indicators including water availability, water demand, and pollution. Think about that for a minute. 80% of the population of the planet suffers serious threats to its water security now. And you have already seen how much of that water is shared by 2 or more states. Climate change is just going to make that worse. Just a couple more statements from the IPCC about the effect on water. And generally speaking, the effect of climate change on water is to make already arid areas drier and already wet areas wetter. So it's a remorseless calculus again. So IPCC found that, quote, broadly water resources are projected to decrease in many mid-latitude and dry subtropical regions and to increase at high latitudes and in many humid mid-latitude regions. Even where increases are projected, there can be short-term shortages due to more variable stream flow because of greater variability in precipitation, and seasonal reductions of water supply due to reduced snow and ice storage. Wonderful. And finally, quote, availability of clean water can also be reduced by negative impacts of climate change on water quality. And this wasn't to me anyway intuitive. For instance, the quality of lakes used for water supply could be impaired by the presence of algae-producing toxins. Remember that much of the water at issue, again, is shared by 2 or more countries. Our next question is, what are the characteristics of climate change that differ from the conditions in which the current international legal regime developed? Variability versus stability. Warmer air, which holds more water than cooler air. More precipitation falling as rain than snow, and that which falls as snow melting more quickly. So the scenario is playing out in our own state of California, where, as we know, a 5th season, wildfire season, now occupies much of the calendar. So the final point, is international water law equipped to deal with climate change? Since a hallmark of climate change is variability from what has been the climate norm, we should ask whether the law, and for our purposes here, international water law, is capable of adapting and adjusting to the new climate reality, a reality that will itself entail change. First of all, one of the main purposes of law, of course, is to create stability and predictability in human relations. This goes for international law as well as for domestic law, but too much rigidity in the interest of producing stability isn't good. It won't allow the law to adapt to disruptions of the climate norm due to climate change. 2 features of the international legal system, especially as it relates to shared freshwater resources, provide hope for me anyway, that the law will be able to adapt. The first feature is the nature of the normative order itself. There is a reason that the fundamental principle of international water law is equitable and reasonable utilization. This was made clear in a 1906 of the United States in a case called Kansas against Colorado. And in case you're wondering, international water law has benefited greatly from the practice of states on the domestic level, particularly the ones that have federal systems such as the United States. And the United States and other countries with federal systems, Germany, Switzerland, for example, have long experience with interjurisdictional water disputes. For us, it's disputes between two U.S. states. In this case, Kansas was the downstream state, the prior user, sort of the Egypt. And Kansas complained that new development of the Arkansas River, which in some places is pronounced Arkansas River, I think in Kansas itself. So new development of that river upstream in Colorado harmed users in Kansas, Ethiopia, Egypt. The court compared the harm to Kansas, and I'm cutting this way short, I'm sure you're thanking me mentally. The court compared the harm to Kansas with the benefit to Colorado and found that equity between the two states forbids any interference with the present withdrawal of water in Colorado. That's not all. The court also said that if Kansas could later demonstrate to the court, come back to the court and demonstrate that Colorado's uses had so increased as to work serious injuries to Kansas' substantial interests, the court would consider stepping in. So it's recognizing that things can change and making allowance for a state to come back to it and say, yeah, things have changed, and I think the balance of uses has tipped in favor of the other state. The second feature of the international legal system that provides hope that the law is capable of adapting is the increasing tendency of international tribunals hearing disputes between states over shared freshwater resources to interpret provisions of treaties in an evolutionary way. This doesn't have anything to do with Darwin, by the way. That is, interpreted to give the terms of a treaty a meaning that makes sense now, as opposed to the meaning the terms may have had when the treaty was originally concluded many years before. This was true, for example, in the Indus Waters Kishanganga arbitration between Pakistan and India. Two states between whom, believe me, no love is lost. Two nuclear states between. Anyway, so in that case, the tribunal interpreted the 1960 Indus Waters Treaty. And you know, take a time machine back to 1960 and think about what the conditions were then. And it was concerned largely with what kinds of dams India could build upstream on tributaries of the Indus. Interpreted it to require India to release a minimum environmental flow through its dam on the Kishanganga River. That's pretty remarkable. The word environment was hardly used in 1960, except in France. Environnement, right? There are one or two French speakers. But, you know, in this country, certainly, and likewise in India and Pakistan, there was no environmental law in 1960. It took, you know, till the end of that decade, really, for the United States to wake up to the environmental implications of human actions and the need to protect ecosystems and the environment and so forth. But when this treaty was drafted, they didn't care about that. They just cared about letting both countries get some use from the Indus system without allowing India to do things that would cut Pakistan short of water. So that was quite remarkable. And I say that even though I represented India in the case. In other words, the tribunal interpreted the treaty in light of norms prevailing in 2013 when it rendered its award, not those prevailing in 1960, which was before the environmental consciousness had awakened. In a word, water uses and applicable norms change, but natural conditions also change. This is the message from the reports of the IPCC. The principles governing the sharing of freshwater resources have to be sufficiently flexible to accommodate those changes, including, of course, changes wrought by global climate change. I believe that properly understood and administered, the principle of equitable and reasonable utilization, the cornerstone of international water law, passes that flexibility test. The question is, how will it be handled by countries? Will the countries sharing the water be able to adapt technologically, not only technologically, but politically, in time to avert real harm and its offspring serious disputes? Perhaps even more importantly, will these countries be able to, and willing to plan their water uses with future impacts of climate change in mind? For the sake of all those relying on fresh water, that is to say, humanity, let's hope so. Thank you. Thank you very much. Now, I'm happy to take any questions, but before doing that, Dr. Camarillo suggested that some of you might be interested in any suggestions I might have concerning career paths leading into this field. And unfortunately, there's very little I can say about my own career path that's of general applicability, since it zigzagged all over the place. But I can give you this advice, which is based on my own experience, and that is just what it is you would like to do. And that sounds simple, but it's not so simple, really. What is it that you'd like to do? Second, prepare yourself for it, even if that's not what you're doing now. Prepare yourself for what it is you'd like to do. And third, work toward it. I've learned that life works in strange ways, and you never know when the perfect opportunity, very possibly one you never anticipated, might come along. No one ever told me any of this, but fortunately, I happened to be more or less ready when lightning struck. So that's my advice to you. Thank you. I don't know, they're bringing in food and wine. I don't want to compete with that. But yes.
So I'm reading that there's something that privatizing water.
Yeah.
Do anything to prevent that, or is there something that they could do that some companies like those opposition that supply the water for themselves to rezone?
The UN has studied that. Of course, the World Bank has had some unfortunate experience with privatization. And generally, privatization doesn't mean transferring ownership of the water to a private entity. It means that the private entity will manage the water supply system or the wastewater system or whatever it may be. But there have been some poster child, if you want to call it that, failures. Probably the main one. So I think now everyone is on alert to the dangers of privatization. On the other hand, sometimes countries really lack the capacity to install and maintain or to rehabilitate old water systems. And sometimes it's only an organization with a lot of money. It may be a country, it may be a private entity, and there are 3 or 4 in France, for example, that comes in to help. And this is not an unalloyed bad thing that's always going to be bad. Sometimes it's good, and sometimes countries need this kind of help. The key is what you're alluding to, I think, and that's oversight, right?
Yeah.
That someone's got to keep track of what's going on so that the people who are served by the water aren't disadvantaged. Yeah. Yes, sir.
The guiding principles would have been developed under today's climate regime. That is, wet areas that are wet, dry areas that are dry.
Yeah.
And it would seem to me that those would have significant impact on how these principles are viewed. And I'm concerned about California water law,
Yeah.
which was developed under a very different set of
Yeah,
circumstances.
yeah. I entirely agree. I don't know where Jennifer is, Harder, but oh, there she is. She's hiding. She's our expert on California water law. I don't think she'd disagree with that things are changing. We have to be flexible and adapt. I don't know what would have developed, but it has to be something flexible,
Yeah.
right? Because otherwise, I mean, the science is good, it's great, but the scientists keep getting surprised, even, you know? They make a dire prediction, and it turns out to be worse sometimes, right? And so flexibility, adaptability, planning, and dare I say it, cooperation. And I really think that is the key to all of this. Cooperation, community, those kinds of concepts. Because you can't go it alone in this new world, I don't think. And I'm not talking about financial resources, I'm talking about cooperation and the use of perhaps increasingly scarce water resources, and that's going to be the case in California. I don't think I did justice to your question, but Mike?
When the court, international court, enters a decree, I mean, what's the incentive for India, for example, to cooperate? I mean, I think students would probably appreciate understanding that, as would I, because I know international law like you.
Yeah. Yeah, what's the incentive for India, for example, to cooperate when the tribunal issues its award, which is perhaps an even better question where it's an arbitration, because arbitrations are freestanding, right? They don't have, in this case, the arbitration was conducted under the auspices of the Permanent Court of Arbitration in The Hague, but they don't have any enforcement power. So the incentive is really one of reciprocity and reputation, all those R words, that really, especially when they're in a situation that is visible and has attracted a lot of attention, as in that case, to lead states to want to comply as nearly as they can, and usually it's not a question of mechanics or ability, funds, or anything like that. It's a political question. And especially between Pakistan and India, of course, both sides declared victory in the case. And they went home and said, da 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 da, you know, which I think any country would try to do. So they want to be seen as complying because they want the rest of the international community to view them as respecting international law. And so that's a strong incentive. I think that's about as good as I can do, unless you want to take my international law course.
I do.
When you mentioned how Gaddafi built the man-made river, it made me think, why didn't he just use that money and technology to build desalination plants by the coast?
Mm-hmm.
So does desalination have a future, because 95 or 98% of the world's water is salt water?
Mm-hmm.
And would it, in a sense, make nations more responsible for their own water sources?
Mm-hmm.
Would it solve some of these legal problems?
Yeah, it's a very good question. Did you all hear it? It's about desalination. It's a very good question. Israel, for example, keeps bringing more desal plants online. I don't know, they have 5 now, or maybe more, 5, 6, which has got to take some of the pressure off the water relations between Israel and Palestine. I'm not sure it has, because Israel still controls everything in the West Bank. But yes, there's more fresh water. It may have been, in Libya, it may have been a question of fuel. It's a very fuel energy intensive process, right? Desalination. So unless you have access to oil or natural gas or something like that to run the desal plant, and you know, perhaps, I mean, and Libya certainly does have oil. So I'm not sure exactly what the thinking was there. Maybe just to demonstrate he could do it, you know. That was his Eiffel Tower or whatever. But I'm sure there are those who are much better qualified than I to speak to that, because they had oil, they didn't use it to run desal. It may have been that at the time, and this is quite some time ago now, desalination plants hadn't developed as much as they have today, right? And Israel seems to be getting, you know, pretty good results from theirs. So one more, if there is one. I don't see one. So let's hit the. Oh, there is one. Yes. Sorry.
Doctrine, how it's been integrated or handled in international cases?
It hasn't been integrated or handled enough, in my view. The public trust doctrine essentially says that a governmental entity holds natural resources in trust for the public, because we all are owners, we all have an interest, the public has an interest in natural resources. It really came from the Romans. It's traced back, you know, a long ways. It's more active. I'm not an expert on the public trust doctrine, but it's more active in some states than it is in others. It's been quite important in California, as I'm sure you know. There has been writing on the role the public trust doctrine could play in international law, but to my knowledge, it hasn't actually been integrated into a decision or even a treaty that I am aware of. Someone may be able to correct me, if so I'd be delighted. It's a very powerful doctrine. Internationally, of course, the question is, who is it that holds the resources in trust, you know, for the benefit of the public? Maybe it's the UN, I don't know. But if you say that international law gives each country, imposes on each country this obligation, you'd probably get some pushback, I think. I'm not sure people are. But the way this works generally is through soft law. Declarations, resolutions, that kind of thing, non-binding instruments that surface this idea of the public trust doctrine and the idea that countries have an obligation to hold resources in trust for the benefit. It's almost a human rights doctrine in that way. And if enough momentum is built up in that way, you know, maybe it will start surfacing in international law. Okay, thank you very much.